What you need to know before filing a petition for appointment of conservator. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine some of the frequently asked questions in relation to the appointment of a conservator in Michigan. This is Form PC667. The State Court Administrative Office provides it so that people who are confused about filing a conservator, these are some of the introductory important questions that are asked and then, of course, answered within the form. So let's work our way through it to better understand the conservatorship process in Michigan. Now, first, we should understand the difference between a conservator and a guardian. And in this particular case, the first two red rectangles on the form, which we're going to cover the difference. But I always like to look at the root word of the word conservator. Conservator, the root word conserve, which refers to financial things, money, to conserve money. Guardian, the root word is to guard over, which really relates to care and well-being. So the way the form answers the question is that a conservator is appointed by a probate court and given power and responsibility of the estate, the financial assets and property of an adult called a protected individual. Now, people often get confused. They'll say, well, Darren, I'd like to get a power of attorney over my family member. And a power of attorney is a document that is created while a person has capacity. It is an estate planning document. A conservator is a process that you go through the court. So there is court involvement in the appointment of a conservator. There is no court involvement in the execution of a power of attorney. Power of attorney is often signed contemporaneously with, for example, a will or a trust or a patient directive. So this is the difference between using the court to intervene in someone's life to appoint a conservator for them versus getting a power of attorney executed and signed privately without the court's involvement. Now, a guardian, as we mentioned, is a person appointed by the probate court and given the responsibility to make decisions and care about another. So the care and well-being. And of course, the form goes on to differentiate between a full guardian and a limited guardian. And the idea really here is that with guardianship, the court could give you full authority over another individual, and you'd have the fiduciary duty to provide for that individual, or can limit the powers. So the idea is really to allow that individual to have as much autonomy and free will and free decision-making authority as they can handle. The next question says, when would a conservator be needed? And it's pretty straightforward here because it's statutory. And I'm going to read it right from the form. It says a conservator may be needed when the individual is unable to manage his or her property and financial affairs effectively because of certain reasons. So again, that first part about unable to manage his or her financial affairs means there's something going on that makes them unable to be able to effectively manage their financial or business affairs. One, he or she has property that will be wasted and used up unless proper management is provided. So again, if somebody's unable to manage their financial affairs, but they don't have any property or assets that are at risk of being wasted, then a conservator would not be needed. Second, funds are needed for the support, care, and welfare of the adult and any of his or her dependents. So again, these are two-pronged tests here, but there's really three requirements here. That there is an individual unable to manage his or her property and financial affairs, he or she has property that will be wasted, or funds are needed for the support, care, and welfare of the adult or their dependents. Goes on to say a mentally competent adult who, because of age or physical limitation, may voluntarily petition the court to have himself appointed. So you could have your mental faculties in place, but because of your advanced age, that may be a basis for doing so. And then the statute goes on to identify the various reasons that would trigger the appointment of a conservator, and they're pretty obvious here. Mental illness or deficiency, physical illness or disability, chronic use of alcohol or other intoxicants, confinement, which could be jail, detention by a foreign power, or disappearance. So somebody is missing, but there are assets that need to be managed. Again, as we work further through this question and answer document, it says, is a conservator needed for an individual who cannot manage his or her property or financial affairs effectively? And then it goes on to answer this question. A conservator may not be necessary if someone already has legal authority. So for example, if there's a power of attorney in place already, and that person has named their attorney in fact to make decisions for them, then there'd be no need to appoint a conservator unless, of course, that power of attorney is defective or being handled inappropriately. So a power of attorney would replace the need for an appointment of a conservator as long as the power of attorney is effective and the person using the power of attorney is doing it correctly. This next part speaks about how you begin this process of appointing a conservator, and it's done by filing a petition for appointment of conservator, which is a scale form, State Court Administrative Office, Form PC669. Now, in my body of videos that we've done, I go line by line explaining how to complete and file a petition for appointment of conservator. Is a lawyer necessary? No. We strongly urge people to be working with a skilled, competent probate lawyer through these processes. It's not easy. It's not intuitive. It's confusing. The court, the personnel are not allowed to tell you or show you how to fill out forms. So it really makes this process very difficult to do without the assistance of a lawyer. What happens if there's disagreements, fights that occur between the parties, the person under conservatorship and the conservator? It speaks about guardians and conservators able to use the mediation process, which is a resolution process, rather than going to court to resolve disputes. So mediation is available for people who are in disputes. What happens when the court accepts the petition for filing? Well, with all petitions, it is filed. There's a requisite filing fee paid. Generally, the court is going to appoint what's called a guardian ad litem. This is a person appointed by the court to review and represent and investigate the circumstances going on around the petition for appointment of conservator. The petition then needs to be served at all of the interested parties as set forth by statute and court rule, given notice of the upcoming hearing. The guardian ad litem will write a report and submit it to the court, and then there'll be a court hearing. And at that court hearing, the court will make an adjudication based on a clear and convincing standard, a clear and convincing evidence standard as to whether the person is in need of a conservator. The person can object and say, I don't want a conservator, I don't need a conservator, or I don't want that person to be my conservator. And they can ask for all sorts of things, including an independent physical or mental evaluation to be done. They can ask for a trial to cross-examine witnesses, and so on. So the statute gives the legal authority for the individual who is being sought conservator to object to both the appointment of conservator as well as the person who is being requested to be conservator. What happens if there's an emergency? If there is an emergency, the assets are at such risk that there needs to be an emergency petition, you can ask the court for that special conservator to come in, protect the assets, a particular type of protective order that allows for protection during the intervening time between the filing of the petition and the full hearing in which the matter would be adjudicated. So again, just a broad-based understanding of some of the frequently asked questions within a conservatorship context. There's lots more to the conservatorship process that is not contained here, and that's why we strongly urge you to be working with a lawyer who understands how to go through the conservatorship process. At the Probate Pro, we are passionate about everything probate. If you have questions about a conservatorship or guardianship or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.